Hi everyone, thank you for joining today's webinar on how to handle flexible working requests. Just so you're aware, this is being recorded and we'll share a copy of the recording and the slides after this. So my name's Alice, I'm one of the solicitors in the employment team here at Harrington Carmichael. I'm joined by Hannah, who is a legal director in our team as well. So the reason why we sort of chose this topic to do our webinar on today is we are getting more and more questions from clients in terms of flexible working, in terms of what level of flexibility can be requested, what the obligations are in granting the requests, in refusing the requests, and how to navigate those. As you'll all be very aware, flexible working has evolved rapidly over the past few years, and this has been driven not just by the pandemic, but also by shifts in employee expectations and by, legislative changes. So what will we be covering in the next hour or so? So firstly, we're going to look at what changes employees are entitled to request under the flexible working regime. We'll look at the requirements for both making a request as an employee and handling the request. So we're looking at timeframes, documentation, what those obligations are and how we need to deal with them properly. We'll look at the risks of getting it wrong. So we'll touch on remedies available to employees where the procedure is breached under the regime. We'll look at discrimination risks and how certain groups might be disproportionately affected by refusing flexible working. And finally, we'll leave some time for questions at the end. So please do feel free to note anything down that you can ask us at the end, or do drop questions in the chat box and we will try and get to as many of them as possible. So we're looking today at the law as it stands as of May 2025, but I think it's worth just talking firstly about the fact that flexible working rights are going to be strengthened under the Employment Rights Bill. So we've got changes under, as I'm sure you'll be aware of, and the Employment Rights Bill currently looks like it's going to strengthen flexible working rights. So firstly, it's worth just flagging that it's still going to be a right to request. So we're not looking at flexible working becoming a default or, there being a default right to switch off, which was previously proposed. So that means that it will still be a request for the flexibility rather than the norm or the rule. One of the biggest changes that the Employment Rights Bill is looking to bring in is this as a test of reasonableness. So we'll get to what the current sort of reasonableness requirements look at in a moment, but it means that essentially it will be a requirement that the company's notification to the employee will have to state the grounds of refusing an application and explain why the company consider it reasonable to refuse the application on those grounds. So currently, that's not a requirement under the flexible working regime. You don't have to justify the refusal to that extent, but that's going to be something which is introduced under the bill. Equally, employers are going to need to explain the reasoning behind the decision in that sort of way, which isn't, to a large extent isn't required under the current framework. And in terms of, a more rigorous approach to dealing with these requests, the bill's proposing to set out steps in regulations made by the Secretary of State that employers must follow to comply with the requirement to consult before refusing a request for flexible working. So currently, whilst there's an obligation to consult, which again we'll get to in shortly, there's very sort of limited detail in terms of the level of consultation, the sort of level of justification behind that, but that looks like it's going to be a more sort of rigorous approach going forward. So under the current law then, which is what we're going to look at today, what kind of changes can be requested then? So employees have a day one right to make a request for flexible working. So there's no qualifying period, and this means that new starters can request this immediately. In terms of sort of what flexibility can be requested, there's sort of three main categories, sort of broad categories in terms of the areas in which they can request this. The first is the hours that they're required to work. The second is the times that they're required to work. The third is where. So where between the employer's premises and the employee's home. Underlying these three sort of categories of requests, there are a wide range of possible working patterns, as I'm sure many of you will have had requests for. So the scope of the legislation effectively includes applications for part-time working, compressed hours, flexi time, home working, hybrid working, staggered hours, among a series of other things. So there are in fact very few limits as to what an employee could request by way of variation. So that gives employees, significant flexibility around being able to ask to tailor their workforce patterns to personal circumstances, so to fit around childcare, caring responsibilities, or even location preferences. And as the tide is changing with flexibility and the sort of culture of flexibility, this is becoming more and more important for employees to be able to request. So what does an employee need to do then in order to make a request? So although employees can make informal requests, under the statutory regime, a flexible working request must meet the requirements that you can see on this slide. Now, there were changes to flexible working that were brought in just over a year ago, and these amended the regime so that when an employee makes their request, they don't anymore have to explain to what effect their requested change would have on the business and how any change may be dealt with. So that was one of the main four changes that were brought in last April. So they don't have to, justify that or give their own business case or, rationale for that. They have to, however, meet what is on this slide. So if an employee does make a statutory request that meets these criteria that you can see, that triggers your obligations to deal with it in a certain way. So first of all, it must be in writing and it must be dated. Secondly, it must state that it is an application under the statutory right to request. Thirdly, it must specify the change that is being applied for and the proposed date in which the change is going to be effective. And fourthly, it must state whether they've made a previous request and if so, when. And this last one is because an employee can now make 2 statutory requests for flexible working within any 12-month period. And this was one of the changes that was also brought in last April. So that's why it's really important just to clarify that they're not, making more than that they, within that 12-month period, have only made 1 or 2 of those requests. So if we have an employee who's made this request, it's fallen under the relevant requirements for the statutory regime. How do we refuse it then? Can we refuse it? What do we do? So this is really common, and we get questions like this a lot. I think given the increased demand from employees and expectation of, flexibility almost being the default or the expectation rather than the exception, employers are often getting caught up in terms of how to refuse these and what they need to do. So many of you will be familiar with the 8 statutory reasons for refusing a request, which are on this slide. So essentially, the legislation recognises that an employer may have, legitimate business reasons why it cannot accommodate this flexibility that's being requested. So these fall under 8 grounds, and one or more of these needs to be relied on when we are refusing a flexible working request. So the first is, burden of additional costs. So the second is a detrimental effect on ability to meet customer demand. So if an employee is requesting sort of hours outside of the normal sort of when you would be servicing customers, and you cannot meet the demand because of that flexibility, that's what that looks like. An inability to reorganize work. So if they're looking at reducing days and you can't reallocate their activities, accordingly, then that would fall under that ground. An inability to recruit additional staff. So if we're looking at, not being able to reallocate to existing staff members, then looking at potentially having to hire an outside staff member to then to cover those hours that are then missing. If there's going to be a detrimental impact on quality or detrimental impact on performance. So often this would look like, so if if typically you work in an office and you're focused on sort of team activities, and by an employee working from home, that would have an impact on their performance, or the performance of a whole of how your business is performing under that. That would fall under that ground. An insufficiency of work during the periods the employee is proposing to work. So typically we see this in where there's sort of flexi hours outside of the standard sort of 9 till 5, or however your hours are sort of structured currently. If they are proposing to work significantly outside of those times, but actually there's not a work demand for that would fall under that one. And then planned structural changes by the business. So if there are structural changes that then mean that the flexibility isn't going to be able to be granted. Now, in selecting a ground for refusal, the wording of the actual legislation suggests that it is a subjective test. Now, what this means is that if you, as the business, currently, or when you sort of get the request, if you consider that one or more of those grounds on the slide applies, then the test is satisfied. So as it currently stands, and this is why I've sort of set out as a preamble that the law is looking like it is going to change under the bill. As it currently stands, this test doesn't import any question of reasonableness. So where you're doing an assessment as to why we're refusing a request, and we've identified broadly that it's going to fall under one of those grounds, the reasonableness of that isn't going to be brought into question. So this means that, assuming that the reason is set out on one of those, an employee could only challenge it if the decision is based on incorrect facts. So rather than being unreasonable, it's simply incorrect. So it's not correct there. And that's really the level of the justification for the refusal that we're looking at currently. So having looked at what changes can be requested, making a request, and the fact that we can definitely, we can refuse these requests, then what is the procedure that needs to be followed to limit the ability to claim under the statutory regime? So these are set out on the slide. So first of all, the employer must handle it in a reasonable way, and that's in line with the ACAS Code of Practice for Flexible Working. So there is an ACAS code that sort of runs alongside the statutory scheme, and this sets out sort of best practice with dealing with the requests and what you should be doing. Although there is no statutory definition of what a reasonable way to handle a request is, it simply says that it is in a reasonable manner. The code suggests that we should be carefully assessing the effect of the requested change for both the employer and the employee, such as, exploring the potential benefits or other impacts of accepting or rejecting a request. There's more detail in the code, but just by way of what the statutory framework says, that's it. Unless you're going to be agreeing to the request in full, there is a legal requirement to consult with the employee and discuss any alternatives prior to refusing the request. So this was another change that was brought into effect last April. So an employer cannot refuse a request unless the employee has been consulted beforehand. So in terms of what the consultation looks like, what level of consultation we need to be carrying out, again, this is underpinned by the ACAS code, meaning that you should be inviting the employee to a meeting to discuss the request, again, handling it reasonably. They should be given the right to be accompanied, as is, common with consultations, but again, that forms part of the code's best practice. And in this meeting, really, you should be having, a reasonable discussion and consider sort of in a two-way dialogue, consider their request, consider, whether there's, any alternatives, if you can't be granting it in full, just having a two-way discussion as to how it might work, what they're looking for, what your where sort of the business standpoint in terms of whether we can be granting it or not, and whether we can potentially find some middle ground there. And talking about the practical considerations involved with implementing the request, because sometimes they are lesser and sometimes they are going to have quite a big impact. So talking about that too. Now, in terms of timings, employers must make a decision within a maximum of a 2-month period. So this means that although many of you will be deciding this in less than 2 months, you must notify the employee of the decision within this period, and the 2-month sort of timer starts on the day in which the request is received by you, not the day that you meet with them to consult. So it's that date that we need to be focused on, and that is the date where we then have the timer running until that 2-month end date. In terms of accepting the request, if we're going to accept it in as they've requested it, or if we can find a middle ground that we're then happy to sort of meet halfway, the new work pattern will be a contractual variation to the employee's employment and will be permanent unless otherwise agreed between you. And if you're going to accept it, there is a requirement to put this in writing in a statement, and you need to do this within 1 month of the changes taking effect. Now, if you are going to refuse the request, you should clearly state the and sort of explain the business reasons together with any additional information which is reasonable to help the decision. Now, this is what the code says. Okay, so the code says that you should be explaining it and providing additional information to help the employee understand, but there isn't actually a statutory requirement to include a sufficient explanation as to why a particular ground applies. But on the flip side, to mitigate the risks, it is best to put this in writing, so we've got this well documented, and equally so that we can show that we've been dealing with the request within the time frame as well. So that's the procedure that needs to be followed. But I think before we move on to briefly covering the claims under the statutory scheme, I think it's worth pointing out a couple of misconceptions we often have about the procedure and about what are the company and the business's obligations are, because often employees can look at the code and and that is their the legal requirements. But although the code suggests, for instance, that it's good practice to give the employee the right to appeal the decision, there's no statutory right to, you don't have to legally give the employee the right to appeal, although they can then make a second flexible working request within that 12-month time frame. Equally, we don't have to be giving them a trial period or a modification of the request. That doesn't, again, that is something which is suggested within the code, but it's not a legal requirement. And equally, there's no, whilst it should be confirmed, in writing and without reasonable delay, again, this forms part of the code. So it needs to be, so it's best practice, but that doesn't trigger the ability to claim. So having sort of given those caveats, which are common ones that we get asked about a lot, what happens then if you don't follow this procedure? So looking at claims then, if you don't follow the requirements, the main claims which can arise out of the flexible working scheme look at procedural failings. So these are set out on the slide. So if you haven't dealt with the request in a reasonable manner, if there was a refusal, if the request was refused without consultation, where it took longer than 2 months, unless it's been, you can agree to an extension, but it needs to be agreed by both the employee and the employer. Where the reason for the refusal doesn't fall within one of those 8 statutory grounds, where the employer has treated the application for flexible working as withdrawn without the grounds applying. So that is the reason that's there is because essentially an employer has the right to treat a request as withdrawn if the under specific grounds, which are if there has, without good reason, the employee hasn't come to the a consultation meeting and has failed to attend another one that you've tried to arrange, and equally those two, but in an appeal situation, if we're granting them the right to appeal, then the request can be treated as withdrawn. Now, an employee cannot bring a claim under the first 4 of these grounds until the employer has notified the employee of the decision on the request and the decision period comes to an end. So it has to wait for that 2-month period to come to an end. Now, although there is this ability to challenge the decision and seek redress in an employment tribunal, claims are under these, procedural grounds are hard to succeed with, because in these instances, an employment tribunal can't question the commercial rationale or the business reasons behind the employer's decision to refuse the request. So this severely, restricts the scrutiny of an employer's business decision. Essentially, the tribunal's role is restricted to reviewing the procedure that was followed, consider whether the request was taken seriously, consider whether it was based on correct facts, so it's not an incorrect decision or incorrect reliance, sorry, and considering whether the reason falls within one of those 8 statutory grounds. But it isn't. What the employment tribunal are not going to do is impose their view as to whether the company or the business have, evaluated each of the statutory reasons. That is a management decision to be made by the company. So it is really limited in terms of the ability to assess that and to really scrutinise it. However, if they did find a complaint that was well-founded, then there are 2 sort of remedies that they can do. So they will make a declaration to that effect. So they will confirm that it is a well-founded complaint, and then they can either make an order that requires the employer to reconsider the application for flexible working, and also they can make an award of compensation, which is up to 8 weeks' pay. So it's quite limited compensation, and that is subject to the upper limit on the amount of a week's pay. So currently, many of you will be aware that that's £719 a week. That is the statutory maximum for a week's pay. And so in total, really, you're looking at 5,700, about 5,700 by way of maximum compensation. But that doesn't mean that if they succeeded in a claim that would be the full amount that gets awarded. Obviously, if they're earning lower than that, it would be lower. And equally, it is for the employment tribunal to assess a just and equitable amount. So what would be just and equitable in the situation? So in those circumstances where it's well-founded, they are what can happen if there was a claim and the employee succeeded in their claim. So I'm now going to pass over to Hannah, who's going to take us through the discrimination risks and what we need to be looking out for on that front.
Perfect. Thanks, Alice. So I'm going to look at the sort of other flip side of flexible working requests. So you've gone through the process, you've followed it to a T, you've got one of your 8 grounds for refusing a request, and surely that should be the end of the story. But it isn't, because employees have other statutory protection which can come into play, and that employers need to be mindful of when considering a flexible working request. Few cases are generally brought in which there is a claim that there's been a breach of a statutory right to flexible working request, which is not accompanied by a claim of either direct or indirect discrimination. And it's very possible for a claim to fail on the test under the statutory regime for flexible working, but to succeed in a claim for discrimination. So in terms of discrimination complaints, typically two types of discrimination claims can flow from a refusal to grant a flexible working request, and that would be either a claim for direct discrimination or indirect discrimination. So just to recap briefly, I'm sure many of you are aware, but a claim for direct discrimination occurs where because of a protected characteristic, A is treated less favourably than B in terms of how the employer treats or would treat others. And indirect discrimination occurs where the employer applies a provision criteria practice, which they apply to all staff and to persons who don't have the protected characteristic of the employee in question. But that provision criteria practice puts people of the claimant's particular characteristic at a particular disadvantage, and the individual has to have been put at that disadvantage. The main difference between the two is that a direct discrimination claim generally cannot be defended by way of objective justification, whereas an indirect discrimination claim can, and we'll come on to that shortly. So direct discrimination claims are actually fairly rare in the context of a refusal to grant a flexible working request. Typically, we've seen more of these claims pursued by men who've had a flexible working request refused as direct sex discrimination claims, because obviously both men and women can make a request to work flexibly, as you would expect. However, there is a perception that many employers tend to look more favourably on requests from women as opposed to those from men, and that can lead to a practice of exposing the employer to potential claims for sex discrimination. A couple of case examples on the slide there. The Walkinshaw case, firstly, in that case, the claimant was denied the right to work part-time following his wife's maternity leave, and he claimed direct sex discrimination because women in his firm were regularly allowed to work part-time. And apart from those actual comparators, he was also entitled to compare his treatment with how a hypothetical female comparator would have been in the same post would have been treated, and therefore he could succeed with a direct sex discrimination claim. In the Armstrong case, he was removed from a support worker roster, which enabled him to meet childcare commitments, and his flexible working request was turned down, and he brought a direct sex discrimination claim. The tribunal in that case noted that two women had been allowed to stay on the rota, and so have been treated more favourably than him. And then in the PricewaterhouseCoopers case, slightly different. In that case, he worked 5 days a week. He raised the issue of working flexibly and asked for 4 days for childcare reasons, but was told, given his role and seniority, that wasn't possible. He revisited the issue again around a year later and asked to reduce his hours down by 50%. That was again refused, but there was a suggestion that 75% of his working hours could be accommodated. The issue in this case was that after this flexible request was, for all intents and purposes, accepted, his manager's attitude towards him changed, and his manager found it difficult to sort of understand why he would want to work flexibly, put his family first, and therefore in that case he succeeded because the tribunal accepted evidence that his career prospects had been damaged, and there weren't similar attitudes displayed towards women who worked flexibly. So indirect discrimination, unlike direct discrimination claims, these are slightly different because they are capable of being justified or defended, as we would say. In this case, the objective justification comes in where the employer needs to show that they have essentially carried out a balancing exercise between the business needs to impose the provision criteria practice they've adopted and the discriminatory effect of that. So it's critical to evaluate the business decisions in those cases, and they should be considered in tandem with those 8 permitted grounds for rejecting the flexible working request that Alice discussed earlier. Unlike claims under the flexible working provisions, the tribunals in indirect discrimination claims will actively assess the legitimacy of the employer's business reasons and the reasons for refusing it to see if they can be objectively justified. So whilst the flexible working provisions, as Alice highlighted, are very much based on a subjective point of view as to whether that decision can be made out, this is where the key difference is between those and the discrimination claims, because there is a greater degree of scrutiny by a tribunal in these cases, which is why a discrimination claim can often succeed where a claim under the flexible working provisions has failed. So just to go through what essentially a justification defence would look like, you have essentially two elements to it. You have to establish a proportionate means of achieving a legitimate aim. Now, the legitimate aim aspect of the test is generally considered to be possibly the slightly easier part of the test to succeed with, because although the types of justification are essentially unlimited, they generally correspond to a real business need. So it's generally fairly easier to sort of pinpoint what the legitimate aim in refusing a request is. There has to be evidence that the actions contributed to achieving that legitimate aim, but it's not necessary for the business to show that they consciously considered that legitimate aim at the time in which they took the action that they took. So they can retrospectively look back at what they've done and what the aim they were trying to achieve were. To show that its actions were proportionate, an employer doesn't need to show that there was no alternative course of action available to it. Rather, they just have to demonstrate that the measures that they took were reasonably necessary in order to achieve that aim. So the actions will not be considered reasonably necessary if there is a less discriminatory means available to have achieved that same aim. So in the case of an indirect discrimination claim, there is a larger degree of scrutiny as to the business decision and the rationale for refusing a request. So a tribunal will make its own judgment. They will look at whether a fair and detailed analysis of the business's working practice and considerations took place, and take all of that into account when determining whether the provision criteria practice is justified. More often than not, the ground of operational need under those 8 grounds of for refusing a request is one that's commonly relied on. Now, the burden is on the employer to show and prove justification, and it's then up to the tribunal to see whether, on a detailed and fair analysis, those working practices and business considerations were reasonable, and to reach their own decision on whether the treatment was justified. So operational need will be sort of scrutinised quite heavily to make sure what they're saying is the justification for refusing the request actually stands up to scrutiny in practice. Costs is the other one. So it's fairly common consideration when considering a flexible working request as to what additional costs are going to arise out of granting a request. And that's quite often can be a deciding factor in whether to refuse a request or not. However, for the purposes of justifying a claim for indirect discrimination, costs alone are not enough. So there's been quite a lot of cases on this issue, and we've sort of arrived at the position now where there's a what's called a cost plus approach. So costs can be a legitimate consideration, but they cannot be the only consideration in refusing a request. So it has to be weighted and balanced along with other factors. And the Equality and Human Rights Commission codes essentially state that companies cannot simply argue that to discriminate is cheaper than avoiding discrimination as a justification for their actions. So we're just now going to look at a couple of specific categories of employees where there may be likely to have consideration of more flexible working requests and perhaps an increased risk of a claim in terms of rejection of those requests. So the first category of employees is mothers. generally speaking, it is still accepted that women do have the primary childcare responsibility, and therefore you're probably likely to see more flexible working requests or requests to work part-time reduced hours from women. Refusing a request can potentially be a PCP that would put women at a particular disadvantage, but there's need to show a disparate impact. So there's been a few cases on this, as you'd expect, in fact, quite a few cases, and it has generally been accepted, and there is a judicial notice that women bear the greater burden of childcare responsibilities than men, which can limit their ability to work certain hours. However, just because there is that judicial note of the childcare disparity, it doesn't necessarily mean that the group disadvantage requirement of an indirect discrimination claim will be automatically made out. So when you're looking at whether a provision criteria or practice has put a group at a particular disadvantage, you have the ability to point to this judicial note as a woman bearing the greater degree of childcare responsibilities, but you also need to look at the particular circumstances. And there have been challenges to that as to whether or not in the circumstances of the woman in question, they were put at that particular disadvantage. Another frequently requests will come from people returning from maternity leave or women returning from maternity leave. Again, similar to the mothers, it sort of comes down to that childcare responsibility. Obviously, requests from employees who are either about to go on maternity leave or return from maternity leave will need to be treated carefully as well. Some organisations have specific procedures in their maternity policies for dealing with returners, and how you and what the process is should you might want to return on different hours to what you did before you went. And it's quite often good practice to have that open lines of communication and encourage employees to think about what they want to do when they return and to make a request in good time before they come back, to enable employers to consider that request and go through that statutory process, and so everybody knows where they stand before the time in which the person returns from the maternity leave. The next discrimination claims can potentially arise from is fathers. So typically, as I mentioned before, we would have expected to see claims for direct discrimination from fathers as opposed to indirect discrimination, because the challenge that fathers who had childcare responsibility had for an indirect discrimination claim is that they struggle to meet the strand of the test of that group disadvantage because of the general acceptance and position that it was still women that bore the greater responsibility for childcare. However, in 2024, the Equality Act was amended, which provided that an indirect discrimination claim can be brought where where an employee does not necessarily share the protected characteristic of the disadvantaged group. So in this case, a woman. But they are disadvantaged at work by their childcare responsibilities in the same way a woman would have been, and therefore they can bring a indirect sex discrimination claim as well. So there has been sort of a shift in the law, which is probably reasonable, because you would expect that if anybody that has childcare responsibility is disadvantaged by a provision criteria practice, that should be a claim that's open to them. So if a woman with childcare responsibilities is protected, a man in identical circumstances would also be afforded that same protection. The other consideration is if you've got employees who are carers of disabled or elderly people, then there is potentially, although they don't have the protected characteristic of age or disability themselves, they potentially could bring a claim on the basis of associative discrimination. So if that puts them at a disadvantage because they have that care and responsibility and they're associated to a person with that protected characteristic, that potentially could give rise to a discrimination claim as well. We're just going to have a little look at disabled employees specifically, because not only do they have the protection of direct and indirect discrimination as with the other protected characteristics, in addition, they obviously have the protection of reasonable adjustments under the Equality Act as well. So a failure to give serious consideration to a flexible working request to alleviate a disadvantage could also result in a claim for failure to make reasonable adjustments under the Equality Act. A couple of case examples there. The RBS case, firstly, in that case, a claims handler suffered from depression and they were agoraphobic, and they found it difficult to travel to work when there were other cars on the road. So they'd reached an agreement where she could come into work between 6 a.m. and 2 p.m. However, difficulties arose when the employer decided that they wanted to alter the working patterns, and then they suggested that they could no longer accommodate the claimant on those working hours, and that she needed to revert back to normal hours. Following a discussion, they came back and said that they would accommodate a 7:30 a.m. start, but no earlier. This wasn't agreed to by the claimant, and she was eventually dismissed. The tribunal found in that case that there was a failure to make reasonable adjustments, because in this case, on the facts, there was no logical basis why 7:30 a.m. could be accommodated as a start time, and that was appropriate, but 6:30 was not. In Walsh, the claimant in that case suffered from Crohn's disease. He'd made a flexible working request to reduce his hours down from full-time to part-time, and he wanted to work 2.5 or 3 days a week. His request was refused, and the suggestion was that arranging a job share, his suggestion of arranging a job share was dismissed as being impractical, and it was refused again on an internal appeal, although the employer was aware that a reduction on to work on a part-time basis had also been recommended by occupational health. In that case, the tribunal found that it would have been a reasonable adjustment to have offered Mr. Walsh a 3-day working week in these circumstances, and that if 3 consecutive days had been impractical, then they could have looked at and discussed other configurations of those 3 working days to perhaps alleviate any concerns about the sort of period of time between him being absent from the office. They also accepted that there would have been some costs associated with implementing that, but that shouldn't have been sort of a deciding factor in rejecting the request. It can sometimes be quite common to assume that shorter working hours are always the answer when considering disabled employees, but that won't necessarily be the case. So you do need to give consideration to other working patterns which may work just as well to try and sort of mitigate the risk and the disadvantage suffered by disabled employees. So, home working arrangements, adjustment to working hours, are also things that should be given consideration. So don't sort of slip into the habit of thinking it's just a case of reducing those hours down. Another area for consideration is also elderly employees. So we no longer have the default retirement age. We haven't had for a very long time now. So we do have an ageing workforce. And it is quite common to see that employees won't necessarily want to simply go straight from full-time working to retirement. Quite often they would like to sort of ease their way out of the business. And this can sometimes present, perhaps an increase in flexible working requests from employees in that particular category, but it can also present a benefit to organisations as well, because they can retain that knowledge and experience of those employees who are looking to ultimately exit, and allow them time to transition those employees out and to plan for succession planning and handover of knowledge and skills. Difficulties can arise where perhaps you have to manage competing requests between younger and older workers. So potentially, if you have a tendency to consider favourably perhaps flexible working requests from more elderly employees and to reject flexible working requests from younger employees, then potentially they could give rise to a direct discrimination claim. However, direct age discrimination claims are one are the only direct discrimination claim, which is also subject to the ability of being able to objectively justify it. So you can potentially defend a claim for direct age discrimination if you can show it's a proportionate means of achieving a legitimate aim. The difference with a direct age discrimination claim defence is is a slightly higher threshold, because you have to demonstrate that your aims have wider society policy aims, as opposed to just simply looking at the business aims as well. This is a really useful tool that's available to employees to keep, retain that skill and experience in the workforce, allowing a handover of knowledge to other generations, and allow for that succession planning without just sort of losing those people on retirement. The last category we're going to look at is where a flexible working request can arise as a result of the manifestation of somebody's religion or beliefs. So an employee may request to work flexibly to accommodate a change in which changing their working hours to accommodate their religious beliefs, and that can be a request for days off for worship, or to not work certain days, or working patterns, and any provision, criteria, or practice which disadvantages an employee in this regard. Oh, sorry everyone, just turn my lights off. Can be considered potentially indirectly discriminatory. So a couple of examples there on the slide. So the first case, the Bishop's Challoner school case, the claimant in this case was a maths teacher and practiced Islam. According to his beliefs, it was essential that he attended prayer at a mosque every Friday, and it would be obviously a matter of utmost seriousness if he were to miss more than 2 Fridays in a row. During the particular school academic year in question, they allowed him a free period on a Friday afternoon in order to enable him to attend prayer. However, in the following academic year, they required him to teach Year 11 maths at that time, and he brought an indirect discrimination claim because that didn't therefore allow him to attend the prayers on the Friday afternoon. The tribunal found that the school's actions were objectively justified because it balanced the discriminatory effect on the claimant against the following factors, which had been taken into consideration by the school in reaching their decision. And that was that there'd been a decline in standard in the GCSE maths, and new arrangements had to be put in place in order to address that. It was essential those arrangements that all Year 11 maths classes take place at the same time, so pupils could be moved up or down between sets according to ability, and it would have been practically impossible to rewrite the timetable to free up that period 5, and providing a supply teacher would have had an effect on continuity of education. So and would have also been too costly. So costs did come into that, but obviously only as a cost and provision. So in that case, they were justified in not accommodating that prayer time. In the case of James, in this case, he was required to work periodically on, she was required to work periodically on Saturdays, and her faith required her to abstain from secular work from sunset on Fridays to sunset on Saturdays, and to attend worship and other activities throughout the day. The employer was a travel agency and involved in marketing and selling cruise holidays, and they considered that it was necessary in the tourist industry to offer a service to customers on Saturdays, which is, I suggest, probably quite fair. However, it understood that Saturday working was unpopular with all of its staff for a number of reasons, including the fact that shortened everyone's weekends and curtailed potential Friday night social activities. Therefore, it only operated a partial service, given rise to a requirement to work one Saturday every few weeks. In the interest of fairness, it required all employees to participate equally. Shift swap-ins were allowed, provided the employee in question ended up working an equal number of Saturdays. Now, the tribunal considered the requirement to work on Saturdays put Seventh-day Adventists to disadvantage, but in this case it was justified. They were satisfied that there was a compelling business need in that case that outweighed the disadvantage to Mrs. James. and that to have made an exception for Mrs. James would have destabilised the Saturday working arrangements and had a profound effect on business. So in that case, again, they were justified in not accommodating the religion and belief. Just to confirm, though, that simply citing business operational needs as a reason for not making that accommodation is not going to be enough. So we have some sort of opposite decisions. In the Zoran's Delicatessen case, the claimant worked as a chef and was dismissed for refusing to work on Sundays. He was Roman Catholic and was obliged to abstain from work on Sundays and other holy days. The requirement to work on Sundays would, in the tribunal's view, have put all practicing Catholics at a disadvantage, and that they accepted that there was potentially a legitimate business need in asking staff to work the extra shifts as the business was getting busier, and it was proportionate to ask the claimant to work those additional shifts. However, it was not proportionate to instruct him to do so without discussing the matter with the other chefs and to try and find a way to accommodate him having not working on the Sundays. So because they didn't sort of explore whether there were any other options available, that's where they sort of fell down in defending the claim in that case. And in the Fugler case, a Jewish employee was refused a day's holiday for Yom Kippur, which that year fell on a Saturday, which was the busiest day of the week for the employer. And they accepted the employer's policy of discouraging the taking of holiday on Saturdays, put Jewish people at a disadvantage, and found that the employer had not been justified in refusing the holiday request, as they failed to consider whether staffing needs could have been met in other ways. So it is really important that you do look at the requests and whether they're, even if you can't accept the request as it's been stated, whether there are other ways that you can accommodate it in order to mitigate the risk of a discrimination claim arising. So just to recap, when we're looking at flexible working requests, some practical guidance and tips. So obviously, firstly and foremost, meet the statutory requirements. If you follow the procedure and consult properly and have an open conversation and dialogue with your staff, that's sort of you're halfway there in terms of meeting the requirements and mitigating the risk of claims. It's important that everybody is aware and can recognise when somebody's making a flexible working request, and that it's channeled through to the appropriate people in order that it can be dealt with and accommodated in the timeframes required. Avoid technicality points. So the outright rejection of a flexible working application because of a sort of minor flaw in an application is a fairly high risk strategy to adopt. A better approach would be to simply inform the employee that there's a fault and ask them to resubmit an amended application. And once that valid request comes through, to consider it properly. An outright rejection on a technical point is unlikely to be looked at favourably by either the employer or indeed a tribunal. Demonstrate serious consideration of the request, and that will sort of put you in good stead, not only when identifying one of your 8 grounds, but also if you do find yourself in a situation where you're having to look at potentially objectively justifying as part of a direct discrimination claim. So the potential business issues should be identified, and then you should also look at ways of mitigating that and discussing the proposal with the employee, because you've always got to have in the back of your mind that whilst whatever you do may strictly abide with the statutory procedure for flexible working, you've always got that underlying risk of discrimination claim in certain circumstances. If you can show you've considered the request seriously, it's more likely that the employer will appreciate that there's been a genuine consideration of the request and engaged in discussions about alternatives and come to a productive solution. Consider alternatives to the request that's been made. So just because you can't accommodate what's set out in the initial request doesn't mean that you shouldn't think about an alternative that could satisfy both parties, particularly in situations where you need to be wary of discrimination risks. Consider carefully whether the role cannot be performed flexibly and whether that belief is justified. Quite often where that sort of position is adopted, that contention doesn't always survive critical analysis, and and is capable of objectively justified. So it's important to consider whether the belief that the role cannot be undertaken flexibly is actually the case, or whether it just feeds into stereotypes, prejudice, or if there is a genuine business need there. Explain the decision and reasons fully and clearly to the employee. Whilst tribunals are extremely reluctant to consider the commercial rationale for employees' decision to reject a request, they do remain entitled to find that a rejection has been made on the basis of incorrect facts, which Alice has already talked about. An employee who receives a clear and credible explanation as to why their request cannot be accepted, and where appropriate, an alternative cannot be accommodated, is more likely to remain an engaged member of the workforce. Ensure consistency. So this is a key one as well, but actually not on the slide. But it's really important that you keep somewhere, especially for larger organisations, some centralised records involving flexible working requests to ensure that decisions are made consistently with previous decisions. Where there are inconsistencies, potentially that's where an employer might struggle to justify an approach being taken in one case, altering and being different to an approach that's been taken in another. And that's particularly important where you may have different requests from people of different sexes whose requests have previously been granted, and they may be relying on some discriminatory distinction between themselves and other successful applicants. So consider the ACAS Code of Practice on Disciplinary and Grievance Procedures. So it could be that a grievance can arise from the rejection of a flexible working request, which could include allegations of discrimination, and therefore it might be that you are then drawn into a grievance process. So make sure you consider that side of things as well. And then obviously maintaining records. Again, it's good to keep a record of requests and any sort of suggestions of discrimination to enable you to keep monitoring diversity within your workforce. And to look at the needs and demands of your employees, and also to enable you to respond to discrimination questions. Although we don't have discrimination questionnaires as a statutory process anymore, it is still open to employees to submit those. So if an employee does submit a discrimination questionnaire asking you particularly around in what circumstances flexible working requests have or haven't been granted, and you don't deal with those questions or respond appropriately, then that can be used later on in a tribunal process in terms of potential inferences of discrimination. So that's the end of the presentation. Now throw it open to any questions. So the first question is, do employees have to notify the employer if they're making a flexible working request relating to their disability? Not specifically, no, but if you are looking to rely later down the line on the failure to grant a flexible working request as the basis of a disability claim, then the employer has to have knowledge of that disability. So it would be difficult to say potentially that the refusal to grant the request is on the grounds of a disability. But in terms of indirect discrimination claims, you don't if people with a disability are put at a disadvantage because, say, there's a specific practice of not granting flexible working requests depending on what the nature of the request is, then that would still be pursuable. But I think it's better for the employee to factor that into their request, because it puts the employer on notice that is the basis of the request, and perhaps makes them more alive to the potential risks associated in not granting a request.
On the next, so Christos, your question, so what happens when none of these really apply, but employers are just using these phrases in the rejection letters, but the reality is they do not apply? I think, like I said earlier, it's a subjective test. So if the business is sort of just about satisfied that one of those applies, then that would really, in theory, meet that request for relying on a statutory ground. However, if it is incorrect, if it is actually not correct, that reliance, so if that would be where the employee could then challenge it on that basis. But typically, more often than not, they will end up going into one of those 8 grounds naturally, and also due to the sort of limited scope on scrutiny on that front.
And just to add to that, if there is then a discrimination element to the claim, then it will be subject to more scrutiny, and that's where they could come a cropper if they haven't really got a legitimate reason for rejecting the request.
Yeah.
Okay, well, I think that's it then. So thanks everyone for joining us this afternoon. As Alice said, there'll be a copy of the recording and the slides will be shared. But otherwise, I hope you have a good rest of the afternoon. Thank you.
Thank you.